Good morning, all. Well, we're here to talk about the Lacey Act. And let me start with a show of hands. Who in the room knows what the Lacey Act is?
No one.
All right, well, we got a few, but not all by any means. The Lacey Act actually isn't new. It is something that was enacted during the Kenley administration in 1900. And it was originally aimed at protecting certain animal species, predominantly birds, because the milliners were using plumes off of white egrets and the species was vanishing, et cetera. So it's designed to ensure the enforcement of laws dealing with illegal trade in wildlife and plants, all right? So what does that have to do with yachts? The Lacey Act has evolved over the years, various amendments. I think the last was in 2008. But that revision was phased in over time. And beginning in December 1 of 2024, the enforcement began as to yachts among a variety of other products. So what it requires is that when a boat is imported into the United States, the owner, I guess through his customs broker, has to present a declaration for any importation. And the declaration has to list all like wood species that are in the boat. If you have even fabrics that are made out of exotic plant fibers, then the plant is on the list of illegal products. And that has to be, you'd have to show genus and species for the wood and where it was harvested and so forth. So it's a fairly onerous set of requirements. And if you don't present it, your boat doesn't get in. So that's the overview. So Umberto, why don't you go a bit more into the legal side of it?
Thank you. Yeah, Umberto Bonavita with Robert Allen Law. It's a pleasure to be here. Thank you to the IYBA and my fellow panelists. It's an honor. So it's kind of ironic because, as Rob Moss mentioned, the law was first enacted, the statute, in 1900 when it was President McKinney, who's actually a hero role model for Donald Trump. And it's interesting because everybody's
It's appropriate to boo when that name is mentioned, but
well, there's a lot of chatter now about the Lacey Act and how it's enforced. The irony is, the Trump administration is in the process of gutting government, making it smaller. There have been cuts in the EPA, the Environmental Protection Agency. So it remains to be seen how this law will be enforced if you have less government employees, and Elon Musk is laying people off or eliminating agencies. But officially, it's a law on the books, and we have to comply with it. Who has to comply with it? Owners, yacht owners, builders like Benetti, yacht manufacturers. And so really, what is it? It's essentially a law to ensure ethical, responsible sourcing of wood material so that you're buying and sourcing your teak or your mahogany from a country that ethically harvests mahogany or teak, basically. And so how do you prove it? What does that mean? Well, it's kind of like a connect the dots. The U.S. wants to know that if your teak comes from a particular country, that it was sourced lawfully, that the applicable fees were paid, that it was exported in accordance with the local laws. So the U.S. just wants to see insurance that, for example, if it comes from Ghana, the mahogany, that it was ethically, lawfully sourced and shipped to Italy, for example, for installation on the boat. And so you have to have all of that documentation available to substantiate when you come to import it in the United States. It's been on the books since 1900. In 2008, they decided to expand it to plants, which includes wood. And then in 2009, they expanded it specifically to yachts. And that's the overview, basically. But as a yacht owner or as a broker, if you're negotiating a deal, now that's one additional thing that you have to kind of check the box on, which is it's a big requirement. You want to make sure that that yacht can come to the United States and be imported. The caveat, of course, is if you don't want to import it, then you're not subject to the requirement. So if you have a foreign flag and you come on a cruising permit, but I don't want to go too much off topic.
No, and to be clear, and I think you've alluded to it, but this applies to both used and new boats. And we'll let Georgia speak in a minute about what manufacturers are doing, but where it gets, they at least know who their suppliers are and can go to them and say, look, I need this information. But if you're dealing with somebody with a used vessel, and say the manufacturer, the builder no longer exists, I mean, what do you do? It's a very, we had one recently, and Georgia was helpful on it, where we ended up hiring a plant expert who went to the boat and told us what genus and species of various woods we had on board. So it is a pain. And one thing I will clarify, I think, is that it's not, the Act doesn't directly apply to builders like Bonetti, but if they're selling boats to Americans that plan to import them into the US, which is especially common with, say, their azimuth line, then their buyers are going to need them, and therefore they have to be prepared to provide them. So, Georgia, why don't you tell us a bit about that?
Okay, it was very difficult in December to try to comply correctly to this rule because no one knew about it. There was only this rule with the form to be filled in and poor instructions, and we had to find out how to comply into our departments. So we focused on, based on the rule, on the floors of yachts, external and internal, the furniture provided by the yard, and the textiles. But the textiles that are permanently incorporated onto the boat, I think about panels that are often made of textiles that are coming from plants. And so we were a little bit scared not to provide complete forms because it works with the HTS codes. So there are HTS codes for the kind of yachts and for the kinds of materials to be declared, but you don't have a complete list saying, okay, you have to tick on the list which materials are in, which could be too easy. And so we hope to have provided insofar a complete declaration, but we are not sure. And important custom agents did not provide us any solution or any consideration about what we were submitting. And so let's hope we are doing well.
Oh, it's you and everybody else out there is kind of struggling with what is to them a new set of regulations and getting clarity on what you can and cannot bring in. Another thing I want to emphasize that we commonly think with boats, well, of course, teak and all the issues surrounding Burmese teak is an obvious issue. And with mahogany, there's different species of mahogany, some of which are legal, some of which are not. But it goes beyond that. And today in boat manufacturer, the manufacturer of boats, they're using a lot of exotic woods, like some Brazilian hardwoods, for example, that may be on the list. And so, Jay, you're boots on the ground in dealing with these issues. And what are you doing when an owner comes to you, not a builder who presumably has more ability to put the list together based on what information from suppliers, but if an owner with a used vessel comes to you, how do you handle it?
Well, I'd like to kind of touch on a few other things that were mentioned here. First off, the reason why there's a bit of panic here in the industry about this is that while the Lacey Act has been on the books for, since 1900, it was a phase that was enacted in December of last year. That phase 7, surprisingly, included yachts. Prior to that, it was furniture, it was, teak decking. It was pretty yacht removed. And all of a sudden, they came in with this list that included all yachts. So the industry was caught a little bit unaware, and it's now a situation where people are trying to understand this. A clarification on something that you said was that it's only wood, and it's all wood, by the way, not just CITES permitted wood or CITES restricted wood. It's all wood articles that are used in the construction of a yacht. That's wood cabinetry, that's flooring, that's ribbing inside the yacht, sailboat, if it's wood, it's got to be reported. What's not reported is furniture or articles that are not permanently installed on the boat. That was a revelation to us when we started talking to the USDA about this. We thought that the teak deck furniture was going to be an important part of them. They said, no, we're not really interested in that. We're interested in all the other wood articles that are going to go on board the boat. The other thing that needs to be clarified is when reporting, the only harmonized tariff classification, and this is a misunderstanding in the industry, the only harmonized tariff classification that has to be listed is that the one specifies that it's a yacht. You don't have to list all the classifications for the fabric and for the chairs and for the flooring and for this and that. It's one classification. Now, all of those articles have to be defined. You have to say, I have so many square meters of cabinetry, of veneer, of this. It has to have the genus, the species, and the country of harvest, the value, and the quantity. That's what the form requires. And it is onerous. It is a difficult task. And the manufacturers, in our experience so far, have done an outstanding job in going back to their suppliers and sourcing this information and doing their best for their clients in order to get this. The responsibility and the liability is not on the manufacturer. It's on the importer. It's on the guy or girl or company that's going to import the yacht. They're the ones that are ultimately signing that form and the ones that are going to be held responsible for the accuracy of that information with USDA and US Customs. So, a used yacht becomes a bit of an issue because you're exempted from builds prior to 2008. If it was built after 2008, you are required to report all this information. And as you said, you have manufacturers that go out of business. You have manufacturers that have not been collecting this data for, how many years? 14 years? Now they're forced to come up with this information and try and backsource it. And USDA, in several meetings that we've had, have taken a pretty hard stance on this. The stance is that we're really sorry that it's hard for you to do that, but you have to do it. And if you can't do it. If it's impossible for you to do it, you have to show us in record format, in documentation, all the steps that you've taken to try and accomplish this, and all the roadblocks and failures that you've come across that says you just can't get this information, and we'll review it and decide what our actions are going to be. And their actions can be not allow the importation, removal of the product, the offending product, fines and penalties, and if it's done with intent, as with any government agency, jail time. So done with intent is really, you're skipping off the rails there.
So, make sure I understand. So any boat, no matter if it has wood products, say, on board that was illegal in 2008, is grandfathered if she were built before 2008.
Correct.
All right, well, that's helpful at least.
What if the wood was sourced and purchased in 2008 and then installed on a yacht that was built post 2008?
The yacht has to report the Lacey Act.
Yeah.
It doesn't qualify when the product was actually harvested. We've seen certifications on some teak product out of Myanmar, which is a red flag.
Right.
But the certifications say that they were sourced many years ago, prior to the restrictions.
Well, I also imagine that there's probably a lot of teak being sold by countries that acquire the teak by transshipment. So you might have a supplier in India that's providing the teak, and there's nothing to indicate where it came from, although the genus and species can be determined, and origin can be determined through examination. It's kind of like DNA. It's not something you can hide. Now, when you get this declaration, you submit the form to CBP, right? You just electronically. And is it reviewed by anyone at that time before the boat's permitted to enter?
The process goes like this. The entry process for a yacht is basically a three-step process. The first step is that somebody wants to import something, and they say, we want to import this yacht. Here's valuation, here's description, here's where the boat is. Customs, if you want to go see it and look at it, this is where it's located. You can go find it and do your inspections. At that time, we have to submit that the Lacey Act information, the EPA information, and any other government agency required information, so that Customs can make the determination if they want to look and see are the engines labeled properly with EPA labels. Is there wood on board? Is the declaration matching this? So the inspection process takes place at that time. And that doesn't mean that Customs has to do the inspection, and they actually do.
They generally don't. Right?
Less than 10%.
Yeah.
But with the next step is that we file more formal documentation or electronically with Customs that explains the classifications and how the values came up with, and the estimated duties are presented. The last step is called liquidation, where Customs, over some period of time, has the ability to review the documentation and the information and decide if they're happy with it or if they want more information. And if they're happy with it, they just close it, and Customs is done with the matter. I have yet to find a limitation as far as this Lacey Act is concerned. As far as review.
Limitation in what sense? Limitation
of review. Of when they can come back, looking for information, looking for you to substantiate how the lumber was harvested or processed. Mm-hmm. And it is the importer's responsibility to come up with that information. You've signed the documentation. You have to have something. You should have something. either from the manufacturer or know that you can source this information readily, that says, hey, this is the due diligence that we did to show that this is how it was, what's the genus, species, and where it was harvested.
Have you had an instance yet, and the enforcement's been going on for less than 4 months, so it's awfully early, where Customs has come out, CBP has come out, looked at a boat, looked at the Lacey Act declaration and say, hey, these don't match?
We haven't had a situation yet where they don't match. We have had situations where, in kind of a strange twist, USDA forgot to put in outboard motorboats. They're not part of the classifications that they listed. They're going to change that. They've already told me they're going to change it. But outboard motorboats wasn't listed. So we disclaim it. We said, we don't have to report it, so we're disclaiming it. And Customs has been a little more aggressive lately, going out there and doing x-ray exams and inspections on outboard motorboats because we're disclaiming it and saying there's, Lacey Act's not required. We have yet to have a situation where Customs or USDA has come back and questioning it.
When you're saying Lacey Act is not required, is it just that a declaration is not required? Because
Correct.
if the boat still has illegal wood products on it, that's still illegal, right?
Yes.
Yeah, okay.
Illegal's illegal.
Illegal is illegal. And Georgia, are you seeing now buyers or their lawyers asking you to include in the contract the requirement that you provide the Lacey Act declaration?
David. Just
He's a good
he
boy.
was the first one, and never before. And we managed with other lawyer to arrange documents for importation of used yachts, and it was difficult for our shipper to recover all documents from our suppliers because the problems are the suppliers.
Right.
That
Although I
now-
assume you're training the suppliers, they
We have
understand that.
We have to. We are training suppliers, in particular wood suppliers, because wood is the most controlled plant,
that's obvious.
obviously. And because they have to be trained, because in Europe is going to be released an heavier rule.
I'm going to stop you
Which is
there.
a-
Just
okay.
alert the crowd. This is very important. We're talking about the Lacey Act now
Yes.
in the United States, but we're about to see something nastier coming up within the EU. So,
Okay.
Georgia, why don't you tell us what that is?
Remaining on the Lacey Act, we can say that now Lacey Act is not asking, as far as I know, for a due diligence on the suppliers. So you don't have
You
to...
have to have that information on file.
You have,
If-
but you don't have to provide it.
Well, the U.S. Department of Agriculture, Jay, correct me if I'm wrong, the legislation says that it has to be available upon request.
Okay, yes.
So you have to have a thorough due diligence file on the sourcing, the certificate of origin, and the exportation of the wood product.
Yes. And we are trying to get everything from our suppliers, but now we don't have to submit it. And now, at the end of this year, it is we will have the release of the EUDR, which is an European regulation about the same issue, so plant declaration to be submitted to EU authorities, and it will require, as far as I know, because things may change insofar, all the due diligence you have done and your suppliers have done for the harvest of plants. And so it's going to be very difficult.
Well, at least-
Some companies, sorry to interject, or some builders are actually hiring outside certification companies like SGS, the company based in Geneva. They basically hire them to say, hey, I need you to do the audit and give me a certificate from SGS that you reviewed
Exactly.
all of our supply chain and you can confirm that it's not illegally sourced. And it's created a boon business for consultants like SGS that they come in and they basically do the dirty work.
And they could do that, presumably
Exactly.
could do that on a used boat to some extent. I don't know if they're interested in doing that, but we're going to have services. in the U.S. For boats coming in where we have no clue as to what's on the boat that can tell us that. But at least if what is coming up covers the same range of wood and plant material as the Lacey Act does, at least with respect to European-built boats, the manufacturers are going to now have the information available
It would be easier.
that we need for the Lacey Act because they have to have it for their own purposes.
Apparently, the EU rule will cover a broader range of materials because
Yeah.
also animal deriving materials and gum and
Well, animal derived, isn't leather, certain leathers covered? Well, leather's taken from illegal, exotic animals, I suppose, or,
If it's from an
Silk.
animal, plant, the answer is yes. And that goes for ivory, that's not sourced properly, and
silk,
shells, and
Right.
all
whatever.
kinds
So
of
it's
things.
going to be, but it was supposed to come into force last year, and then they changed to end 25 and or begin in 2026.
but
So
it's a
let's
coming.
see.
Okay, well, let's see if we have some questions from the audience here.
Hang on, Willie. Does Customs have an actual form?
It's not a customs form, it's a USDA form, and it's called the USDA 505 is the form number. And if you Google just Lacey Act form, it pops right up.
Solo quello con il panda.
Other questions? Okay, hang on a second. Anthony? Running the gauntlet here.
So interesting.
Morning, everyone. What triggers the actual obligation to declare? You mentioned an import. So my question would be, is there a possibility of a temporary importation in the US? And if a boat comes in just for chartering or just for a quick cruise, would that trigger
Well,
the
if it's
request?
coming in under a cruising license just to visit, then that's not an issue. If it's coming in to charter to a U.S. resident, then the boat has to be imported. So the importation, the declaration requirement would then kick in. I don't know that there's anything in between, Jay, where you're either not importable or you are importable, and if you are importable, then you have to file a declaration. Is there anything else to say about that?
Sure. So the temporary importation is a good question. USDA has stated that if the importation falls under Chapter 98, which is exemptions, it's U.S. goods returned, it's temporary importation bond entries, and some other things, that Lacey Act is not reportable. We don't have to report.
Let me stop you there. So if it's a U.S. goods return entry, you do not have to file a declaration.
Correct. And if it's a temporary importation entry, you do not have to file.
Yeah, it's really if you're formally importing the yacht, paying a duty, and importing it into the United States. But if you're in the U.S. on a cruising permit, you're foreign flag, but you essentially stay in U.S. waters, I mean, there's case law from U.S. Customs that they'll deem that as a constructive importation, and then they'll treat it as though you imported it, even though you didn't formally file an entry, because you're abusing the privileges of the cruising permit. Mm-hmm. But the trigger is the importation. So if you didn't import it, you're not technically subject to the requirements.
And I'm assuming that with respect to U.S. built boats, that the assumption is that if there is illegal wood products on the boat, those wood products had to have been imported separately to be installed in the vessel. So there is another control mechanism. Whereas with a foreign-built boat, we have no idea where the materials on the boat came from, and there's no other means of establishing that other than through this declaration.
Yeah, that's absolutely correct.
Okay. David?
When you said a temporary import, does that include a boat show bond and a foreign trade zone?
Yes, it does.
Okay, so no Lacey Act for either of those?
That's correct.
Other questions? Get a little tough. Hey, Carla.
Thank you. It's a very interesting topic. And you mentioned the link between the flag and the registration and the customs situation of the yacht. But is there a written link on the legal grounds between the registration of the yacht and the customs status? Because in Europe, there are just simplified rules for the documents that yachts should have while moving from the EU or arriving to the EU in terms of documents, but no difference because it's not the flag deciding the customs status of a yacht. So if you have some further insights on this link, it could be helpful because sometimes we have to deal with the customs in Europe and they ask us, but when the yacht went to the US, what was the procedure, what was the document, and about the link between the flag and the customs status? Because there should be no link.
Well, there isn't in the sense that you can have a foreign flag vessel that comes to the U.S. It can be used here privately, generally under a cruising license. There's no importation requirement. But if you have a foreign flag vessel that comes into the U.S. and, say, wants to charter here and has to be imported, then these issues kick in. But your question actually raised another question in my mind. And that is, in Europe, we have boats that are now commonly imported so that they can charter. And I wonder whether now, to be able to do that, say under the French commercial exemption or reverse charge mechanism or whatever procedure you're using, are they now going to have to show that they meet the European requirements?
This was my point, because if you look at the whole picture and you import in Europe yachts coming from the US and you have imported them, the flag remains the same, but they are
it's the
European
fact of importation that triggers it.
Yes, they are, from a customs point of view, you must consider them European item from a customs point of view. The flag remains.
No, they're going into free circulation in Europe.
Yes, but it's not, technically speaking, free circulation. So I think it's a topic that has no answer, in my opinion.
Yeah.
It lays in the procedures. But
Well, I mean, you could have a yacht. I mean, dealers do this all the time. They import yachts from Europe. They formally pay the duty. It's officially goods that have been imported into U.S. commerce, but it's not flagged. You don't have to have a vessel flagged.
You don't have to flag because the customs status depends on other procedures which are not the flag.
The only relevance that flag has is that the flag could determine whether you have to import the boat. I mean, for instance, if you put a boat, one of their azimuths, that you put it under a U.S. flag and you bring it to the U.S., well, with certain limitations, you don't have the ability to not import it. If the boat's going to be here on other than a transitory basis, you have to import it. Whereas if you had it under a foreign flag and we're using it privately, you wouldn't have to. So the flag, I think, is relevant only insofar as it determines what customs procedures you're required to follow.
Mm-hmm. Yes, because we have an issue in Europe sometimes. Non-European flagged vessels and non-European flagged yachts are treated as non-European from a customs point of view, and yachts with VAT paid in Europe because of many situations receive a temporary admission procedure because of the flag,
Right, that's sort of the
irrespective
same thing
of
I'm
the
saying.
VAT paid. So
Yeah.
this
Temporary admission, I'm assuming, would not trigger
Yes.
the European requirements, whereas importation, let's hope so, importation under one of these schemes, you know, I mentioned the FCC and the FCE, the reverse charge mechanism, because they're probably the most common, but not the only ones available. That's going to be potentially problematic, especially if the European requirements are broader than the American requirements.
Thank you, Rob. Thank you, Berto, for these insights. It's a very critical point. Thank you.
I have a question from the only other gentleman in the room besides me who was here during the McKinley administration.
Well, I wanted to let everybody know that at 5:30 today, there's going to be a reception in the IYBA area down there in the studio. Everybody who's here is invited. I don't know if the announcement was made previously. I also wanted to say one other thing, given what my esteemed colleague Rob Moss took a shot at the President of the United States, that if you have a problem with the United States government, you may want to think about that type of remark, or working with the law firm of Michael Moore and Associates.
Do not get me started.
All righty then. And we have another question from the audience here.
Well, I can try and follow that. So the Lacey Act is what's triggering, the form that you mentioned is importation of the yacht. Do I understand correctly that for U.S. builders of yachts, this act is being enforced already? In other words, there's a verification system that...
It's what it is with U.S. builders is it's not that the yacht is going to be subject to Lacey Act declaration if it comes back in later. It's that the materials that go into the yacht had to have been imported at some point, right? We don't grow illegal teak. And those imports of the wood products themselves would have been reviewed and required Lacey Act compliance. So the assumption is that whatever's put into a boat built in the U.S. has already been reviewed. But now we have the reverse with those boats potentially going to Europe. The EU, which has a similar act but a broader act. What's going to happen with them? So.
Just a word of warning. I know that we keep mentioning teak and something. It's all woods. It's oak and pine and veneers, and it's all wood. So
But
I don't want people to misunderstand that. It's
Like
just
I said earlier, there's illegal mahogany, depending upon where you got it. I mean, there's illegal Brazilian hardwoods, and there are really some kind of cool woods out there that people like to put in boats, but it's going to be an issue.
Yeah, one point to that. The U.S. government is not going to tell you, what countries are prohibited or, de facto considered illegal or, irresponsibly sourced black market wood. That's what makes it even more challenging because they don't have a list that says, well, if you bring it from Burma, then that's illegal. In theory, you could have wood from, the Congo, which is a red flag kind of jurisdiction for wood, and it could technically still be lawfully, ethically sourced and be in compliance with the Lacey Act, even though it's from the Republic of Congo. So it's a further challenge. And then, an interesting thing maybe for, Georgia, are you seeing a shift maybe now to more composites and people just saying, I don't need this headache. I'm just going to get composite teak, pseudo teak, and I don't need the wood.
No, not so much. No, now we are trying cork because cork is very easy to install and also to treat, but we tried it on the CDEC series of Azimuth, which is all about environment protection, etc. But at the end of the day, teak is preferred. Because on cork it remains stamps and spots, and so at the end of the day I'm not seeing a lot of composite.
It has to feel good on your bare feet.
Yeah, that's the problem. A guy building a €100 million yacht is not going to like the idea that he has to put some composite material on his deck, that he can't use teak. And there is legal teak, right? I mean, there's teak from India and some other places, but I don't know that the quantities are sufficient. It's difficult to source.
It's difficult to source and to distinguish because there is the black market who make false certifications.
Except the problem with that is, as I said, there's a kind of a DNA aspect to it. Is you can determine where it came from. So.
Yeah, I've just got a couple of quick things, a couple of assumptions. I assume that nothing has happened in the US to this effect as yet. No boats have been arrested or whatever the right terminology is.
It's too early.
So far,
There was a furniture manufacturer that was civilly fined a good deal for kitchen cabinetry, where they misrepresented the origin of the kitchen cabinets, wood. But I'm not aware of anything pertaining to yachts, other than, you know, my esteemed British colleagues. I know there was an incident with Sunseeker and
Ocean Co.
Jeff Bezos. I believe that was in England. It didn't involve the Lacey Act, but I'm not aware of
It was Bezos's boat.
Yeah.
The
And
Sunseeker
had illegal teak that was put in by Ocean Co. And Ocean Co. got a hefty fine over that.
and Sunseeker was investigated by the U.S. Department of State here.
But the fine
With
for
regards to
Sunseeker
Lacey Act.
was a European or maybe an English fine, but I don't
Yes.
think it was a U.S. government fine.
No.
So my second assumption is if it hasn't happened yet, it will. So what happens when it does? Who is deemed to be responsible? Is it the UBO? Is it the manufacturer? Is it the supplier? I'm going to come to that. And secondly, how do you fix it?
Well, I mean, the lawyer answer is everybody in the chain is going to be responsible because, you know, they'll go after the owner of record, and the owner of record will turn around and sue Benetti to be indemnified.
We sue our suppliers.
There was a
And so
breach
it's a
of
chain.
implied warranty. And,
But who are the U.S. government going to go after? Everybody, or
the importer
The
of record.
importer.
The importer of record.
Well, in the boat itself, the import of record with respect to fines and so forth. But if you have a boat that has illegal product on board, as Jay said earlier, they're going to either make you rip it out or get your boat out of here. So it's potentially catastrophic, depending upon how aggressive they get and how wide the enforcement efforts become.
the boat could just turn around and leave U.S. waters, and that would solve the U.S. problem, would it?
Yeah, but if you're a guy who bought a boat to use in the U.S., that's not a satisfactory answer.
One of the things that we're seeing is that we're getting a lot of yacht brokers contacting us kind of on the 11th hour. They have a buyer that's interested in a boat and a seller that's interested in selling. And they need to import the boat. And honestly, they should have done this prior to offering it for sale. That's the way the rules read. But however the sales buyer and seller were sourced, there's interest. And now it comes down to we have to import the boat, and it's 11th hour. And we have a deal, we want to close this Friday, and let's import the boat. We'll pay the duty or whatever. And we have to go through this process of saying, are the engines compliant? Do you have the proper Lacey Act documentation? And it really can bring everything to a screeching halt, especially for used boats. Again, the manufacturers are doing a fantastic job. USDA, in an email to me the other day, said, I told her I was going to give a little, be on this panel, and she said, just please tell the manufacturers and the dealers that they make every possible effort to source and keep this documentation for as long as you possibly can, because the boat's going to be sold over and over and over again, and somebody's got to have that documentation. And I think you're going to see yacht documentation specialists and attorneys say, we need to see that source documentation, the Lacey Act documentation.
And I'm assuming there's no statute of limitations. If they inspect your boat later for some reason, God knows why, and find illegal wood on board, and the boat was built after 2008, then even if it was 10 years earlier that the boat was brought in, I imagine you're going to have a problem.
As I said, I have yet to find anything that states a statute of limitations. When customs processes an entry, they close it within about a year, and then 5 years after that date of liquidation, then they file it away, and it's pretty much done. I haven't seen anything like that with regards to Lacey Act and any kind of time limitation.
We're about out of time. Jay, I have two comments. One, use boat docs. Your documents will stay there forever. And two, I resemble that remark about yacht brokers in the 11th hour. Ladies and gentlemen, thank you very much for an entertaining and interesting panel. This is really important stuff, and it's going to affect the community for quite some time to come. Thank you.